Hello and welcome to the fourth annual Originalism Symposium hosted by the Federalist Society at the University of Virginia School of Law. My name is Julia Morose, and I'm the chapter president of the Federalist Society here at UVA Law. It is my pleasure to thank you all for being here today. Last year at the Supreme Court, individual rights were a key theme from the major cases. We selected this year's symposium theme, Rights Revisited, to grapple with unsettled questions from these cases about the substantive rights secured by the Constitution and the methodology that jurists have applied, or perhaps should be applying, to ascertain the scope of individual rights. We begin, appropriately, I think, with a debate about Dobbs. Later in the day, we will tackle difficult questions about the Fourth Amendment's right to privacy, the First Amendment's Free Exercise Clause, and the Second Amendment. We hope that each panel will offer something for everyone and that you will join in by asking panelists your questions using the Q&A function. Before we get started, I would like to take a minute to thank the people who made today possible. First, and most importantly, our symposium chair, Jay Cranier, has worked tirelessly over the past few months to make this thought-provoking event possible. He was assisted by our symposium committee, David Onen, Faith Chutkowski, Christian Diaz-Ritz, Connor Fitzpatrick, Austin Gaines, Mike G., Ann Crocher, Aquila Maliakel, Charlili Marquis, and Christopher Pavlinac. I would also like to thank our advisor, Sai Prakash, for his continued support and advice. Finally, I would like to thank our distinguished panelists and moderators. We are thrilled to have you here today. It is my pleasure now to turn it over to our symposium chair, Jay Cranier, who will introduce our first panel of the day. Thank you again.
Thank you, Julia. And without further ado, we'll begin with our first panel, which is, was Dobbs an originalist opinion? Since the moment it was decided in 1973, Roe versus Wade drew the ire of originalist-minded commentators who insisted that the Constitution does not protect the right to an abortion. This past June, in Dobbs versus Jackson Women's Health Organization, the Supreme Court vindicated these originalist complaints by overruling Roe versus Wade and returning the issue of abortion to state governments. However, some originalists have taken issue with how the court reached this result, questioning whether the court's reliance on history and tradition can be squared with public meaning originalism. In contrast, other originalists have championed Dobbs as a triumph for the methodology. We are fortunate to be joined by two scholars to discuss the issues that arise from this dispute, including the role of history and tradition in constitutional interpretation, as well as the appropriateness of stare decisis. Moderating this discussion will be Mr. Phillip D. Williamson. Mr. Williamson litigates complex matters in state and federal courts at Taft, Stettinius, and Hollister. He has briefed appeals in multiple U.S. courts of appeals, including the 6th, 7th, and 9th circuits, as well as state appellate courts in Ohio, Kentucky, and Georgia. Mr. Williamson has also represented amici at both the cert petition and merit stages in the U.S. Supreme Court. Prior to joining Taft, he served as a law clerk for Judge Raymond M. Kethledge of the U.S. Court of Appeals for the 6th Circuit, Judge Amul R. Thapar of the U.S. District Court for the Eastern District of Kentucky, and Judge Levensky R. Smith of the U.S. Court of Appeals for the 8th Circuit. Mr. Williamson is a graduate of the University of Virginia School of Law. Mr. Williamson?
Thank you, Jay. It is a pleasure to be back at the alma mater. So welcome to you all to Mr. Jefferson's Zoom University. We have two wonderful panelists for you today. I'm going to keep my short and sweet, partly because I have a head cold and it'll spare my voice, and partly because I think you want to hear from them rather than about them. My apologies. So first up, we will have Professor Lawrence D. Solum, who is a William Matheson and Robert Morgenthau Distinguished Professor of Law here at Mr. Jefferson's University. Prior to joining the faculty in 2020, he was a member of the faculty at law schools we will not name. He clerked for Judge William A. Norris of the U.S. Court of Appeals for the 9th Circuit, worked for the law firm of Cravath, Swaine and Moore in New York City, and received his JD, magna cum laude, from Harvard Law School and his BA with highest departmental honors in philosophy from the University of California at Los Angeles. His remarks will be followed by Professor Lee Strang, a good, strong Ohioan. He is the John W. Stapler Professor of Law and Values at the University of Toledo College of Law. Before that, he was a visiting professor at, again, law schools that we need not name. In 2016, he was appointed to the Ohio Advisory Committee of the U.S. Commission on Civil Rights. And prior to entering teaching, he was a judicial clerk to Chief Judge Allison Batchelder of the U.S. Court of Appeals for the 6th Circuit, herself a graduate of Mr. Jefferson's University, with an LLM in 1988. So we have UVA connections on both sides. He was also a litigation associate at Jenner & Block in Chicago and a graduate of the University of Iowa and Harvard Law School. And with that, I'm going to turn it over to Professor Solum. Was Dobbs an originalist opinion?
Thank you so much. I hopefully am sharing my screen. And let me just dive into it. So our question today is whether or not Dobbs is an originalist opinion. And to get a handle on that question, we might start with a prior question, which is, what is originalism? And that question, I think, is complicated, but not in ways that we need to linger on today. The best way, I think, to think of constitutional originalism is as a family of theories. So there's a form of originalism that focuses on original intent and a form that focuses on original methods or original law. There are different members of that family. I'll be operating from the framework of public meaning originalism, the predominant form of originalism. The originalist family share two basic commitments to the fixation thesis and the constraint principle. So the fixation thesis is the idea that the meaning or linguistic meaning in context of the constitutional text is fixed. The words mean what they meant at the time each provision of the Constitution was written. And the second commitment is to the constraint principle. This is the idea that the Constitution is binding, that judges do not have the power to modify, enlarge, or subtract from the rights and powers identified in the constitutional text. Public meaning originalism holds that when we investigate the meaning of the constitutional text, what we are looking for is the public meaning, the meaning that was communicated to the public at the time each provision was framed and ratified. Now, original meaning is relevant to non-originalists. So, for example, famously, Justice Kagan said we're all originalists now, but by that, she did not mean we're all committed to the constraint principle. Instead, what she meant was that even non-originalists will consider the original meaning of the constitutional text in making their decisions. And finally, I want to say that there's a complicated topic that's very involved in today's discussion, and that is the relationship between originalism and precedent. I'll have more to say about that later. Okay. So is the Dobbs majority opinion, the Alito opinion, originalist? There are some problems here with answering the question. And one of those problems is that the parties did not make originalist arguments. So petitioners and respondents argued from a constitutional pluralist framework. Most of their arguments sounded in precedent and historical practice. Few of their arguments dealt with the constitutional text. This came out in oral argument when Justice Thomas asked the advocates for the challenge to Mississippi's statute to connect their argument to the constitutional text. The answer was one word, liberty. As if that constituted an originalist argument. I'll come back to the word liberty in a little bit. The Privileges or Immunities Clause was not briefed by the parties, and the parties didn't discuss the relationship between originalism and stare decisis because they had nothing to say about the original meaning of the constitutional text. So when we ask the question whether a given opinion is originalist, that question has four dimensions. So the first dimension concerns outcome. We can ask the question whether or not the outcome reached in a case is consistent with original meaning. The second dimension concerns the holding of the case, or the legal rule established by the case. We can ask the question whether or not the holding is originalist. The third dimension of the question concerns the reasoning. Is the reasoning that leads to the holding originalist or not? And then finally, we can look at other statements in the opinion and ask whether or not a dictum or collectively the dicta that are pronounced, but not part of the reasoning that leads to the holding, are consistent with originalism or not. So those are the four dimensions I'm going to be discussing. But before I do, I want to introduce an important concept. Professor Strang, who is really one of the most important and creative forces in originalist theory, has discussed this already in connection with the court's opinion in Dobbs. So the idea of the gravitational force of originalism is based on another idea, the idea of a second best, right? So you may have heard of this idea. A second best is contrasted to the first best. And in the context of originalism, we would be talking about a second best opinion, one that does something that originalists would approve of, but that falls short of an originalist first best opinion, one that is thoroughly originalist. In other words, one that reaches an originalist outcome and as an originalist holding based on originalist reasoning and includes no non-originalist dicta. So why second best originalism? Because first best originalism may not be feasible. For it to be feasible in a given case, of course, you got to have 5 votes. And because there are not 5 lion-hearted originalists in the mold of Justice Thomas on the Supreme Court, it will frequently be the case that 5 votes just can't be obtained. Nonetheless, originalism may exert gravitational force. That is, the result that would have been reached if there had been originalist reasoning may pull the court in the direction of an outcome that is consistent with originalism. That is, you can reach an originalist outcome for non-originalist reasons. And Dobbs may very well involve the gravitational force of originalism. Okay, so our first question, was the outcome consistent with originalism? As framed by the parties, the only question presented was whether the original public meaning of the due process of law clause invalidated the Mississippi statute. No plausible originalist case exists that it does. For one thing, the word liberty in the context of the due process of law clause of the 14th Amendment means freedom from restraint, freedom from things like arrest. It's in a phrase that talks about liberty, life, and property. These are all things that courts can take away from people. There's no evidence that the original meaning of liberty encompassed all rights of any kind. And even if it did, what the 14th Amendment requires is due process of law, that is procedure. There's just no originalist case that the due process of law clause of the 14th Amendment creates implied fundamental rights. That's living constitutionalism through and through. I want to note that there are some originalists who see very limited forms of what they label substantive due process in the 14th Amendment. I think they're wrong, but even if they're right, they wouldn't lead to their arguments, which are very limited in nature, would not lead to the conclusion that Roe v. Wade could be defended on originalist grounds under the due process of law clause. The privileges or immunities clause was not at issue because it wasn't argued by the parties. And so either it should not have been addressed by the court, or the court should have called for additional briefing and re-argument on the privileges or immunities clause issue if the court had wanted to write an originalist opinion. That did not happen. I just want to sort of make it clear. My position is that after briefing, the Supreme Court should have called for additional briefs. And at oral argument, there should have been substantial focus on privileges or immunities. And if the parties were not willing to argue that, the Supreme Court should have appointed counsel to argue those issues. And we might have gotten then an opinion that was more consistent with originalism, assuming that 5 justices were willing to go for such an opinion. And I think we have very strong reasons to doubt that there were 5 votes for a thoroughly originalist approach in Dobbs. But the outcome was originalist. What about the holding? Well, I can't give you a complete analysis of that question now, because in order to do so, we would have to figure out what is the holding of a case. There are 3 major approaches to that question. The first of which is the most traditional approach, and the approach that I have argued originalists should adopt. This is the approach that says the holding of a case is the ratio decidendi, where the ratio decidendi, or reason for decision, is understood as the legal norm or rule that is entailed by the reasoning necessary to reach the outcome on the basis of the legally salient factual characteristics of the case and the issues that were put into play by either the parties or the judges who heard the case. The second theory results in much more limited holdings. A second theory of the holding is the legally salient factual characteristics theory. Under that theory, the holding of Dobbs is quite limited. A third theory of holdings is that holdings are like statutes, that when a court says we hold that, or otherwise announces a legal rule as the basis for its decision, that is the holding, even if it reaches far beyond the facts of the case and the issues put in play by the parties or the justices before the decision was reached. So a very narrow holding in Dobbs is clearly consistent with originalism. If all Dobbs does is invalidate this statute, then that would be consistent with originalism. But if the Glucksberg approach is part of the holding, then Dobbs' holding is obviously inconsistent with the original meaning of the constitutional text, because the Glucksberg approach is substantive due process. The Glucksberg test is a test for unenumerated substantive due process rights, and such rights should not exist from an originalist perspective. Was the reasoning originalist? No. The reasoning was based on substantive due process. And as I've said now several times, I'm beginning to feel somewhat repetitive, that's inconsistent with the original public meaning of the 14th Amendment due process of law clause. There is a counter-argument, and that counter-argument is that stare decisis is either consistent with or required by the original public meaning. That's what OPM means, original public meaning of Article 3. So now that's a complicated question. We really can't go into the evidence for that question in this brief 1-hour session. And I certainly can't recount all of the evidence today. I believe that stare decisis is consistent with Article 3, but I do not think that Article 3 requires courts to follow demonstrably erroneous precedent. So I agree with Justice Thomas's articulation of the originalist standard for overruling precedent. If precedent is demonstrably erroneous from an originalist perspective, then the obligation of an originalist judge is not to follow the precedent. I believe there is no good evidence that Article 3 of the Constitution has baked into it the proposition that courts must follow demonstrably erroneous precedent. I have seen no such evidence. I believe no one has produced such evidence. And therefore, I think that this defense of the reasoning in Dobbs on originalist grounds is not viable. Just point out that if following non-originalist precedent is required by originalism, then originalism is really relatively unimportant as a constitutional theory. Okay, are the dicta consistent with originalism? Justice Thomas's concurrence demonstrates that the answer to this question is no. That is, Glucksberg is non-originalist, and the discussion of Obergefell and Griswold in dicta is not originalist. And footnote 22, the only place where the court deals with the privileges or immunities clause, is not an originalist footnote. If we want to talk the details, I'm happy to explain why the very shallow and almost totally unreasoned discussion in footnote 22 relying selectively on a tiny number of secondary sources is not good originalism. Okay, so to sum up, was the outcome originalist? Yes. Was the holding originalist? Maybe it depends on what you think the holding is. Was the reasoning originalist? No. Were the dicta originalist? No. Taken as a whole, Justice Alito's opinion for the court is best described as based on constitutional pluralism, the approach that says we consider precedent, historical practice, we consider the constitutional text, but it's only one of several factors, and we might consider constitutional values and institutional concerns as well. So if I were forced to give one answer to the question that frames the panel, my answer would be no. But what I would prefer to say is that we should be asking 4 questions, and that only the answer to the first question, was the outcome originalist, is yes. Thanks very much, and I will stop sharing my slideshow at this point.
Well, with that, I'll turn it over to Professor Strang. Thank you, Professor Solum.
Thank you very much, Phillip. Thank you, Jake Rainier and Julie Rose and the entire Federalist Society for hosting this wonderful scholarly gathering, and for Mr. Williamson's good offices moderating today's panel. It's an honor to participate with Professor Solum, whose scholarship is extraordinary, and this is a really important topic. And even from his remarks today and his other scholarship that he's published or other remarks he's published and done interviews on, I've learned from what he's argued. And I'm looking forward to the questions and comments from people in the audience. So the title of my remarks this afternoon is Originalism in Eclectic Bodies of Law. And in my brief time, what I'm going to argue is that Dobbs is one of many examples of originalism's operation in constitutional law areas best characterized as eclectic. To support this claim, I'll make quick 3 moves this afternoon. First, I'll describe originalism, its core commitments, and I'll build on a lot of what Professor Solum had said. I'll also spend some time on stare decisis and precedent. I'll say some things consistent, maybe some things in tension with what Professor Solum had said on that point. Second, I'll explain how Dobbs and substantive due process are examples of widespread phenomenon of eclectic areas of law. These are bodies of law that contain large proportions of both originalist and non-originalist aspects and doctrines. Third, I'll argue that Dobbs is a good example of how originalism should operate in eclectic bodies of law. It employs stare decisis to prudently navigate the doctrine back to the Constitution's original meaning. There's another way to think about the argument that I'm proposing today, that so long as one agrees with the following 3 propositions, it's possible, and I think it's best to argue, that Dobbs is an originalist decision. The first proposition is that the Constitution's original meaning is authoritative. Second, that originalism incorporates a doctrine of stare decisis that requires federal judges to give respect to precedent. Third, that American constitutional law, including substantive process, is best characterized as eclectic, that is, containing significant elements of both originalist and non-originalist doctrine. Let me note two stipulations before proceeding. First, my remarks presume what I think is the conventional view, which Professor Solum, I think, also articulated, that Roe and Casey, as interpretations of the 14th Amendment Due Process Clause, are not correct. And I think most or almost all scholars accept that characterization. Second, unless otherwise indicated, when I refer to Roe or Casey, I'm referring to Roe and Casey and the constitutional right to abortion. So my first move this afternoon is to describe originalism and its simultaneous focus on fixed original meaning and its privileged place for precedent. Originalism came on the landscape in a sophisticated form in the 1970s, in fact, as critical of a wide array of non-originalist precedents that many of us learn or teach in constitutional law, and many of them continue to be so-called good law today. As Professor Solum described, there are two key commitments that are relevant to my arguments today. The one is the fixation thesis, which he described, and second, the contribution thesis that he's described elaborately and elegantly in his scholarship. Over the past 20 years, and here's something where I'm saying something in addition to what Professor Solum was saying, originalism has evaluated its relationship to stare decisis. I think initially there was relatively little attention given to stare decisis, and the attention that was given used a syllogism to arrive at a particular conclusion. And the idea was that to the extent that there was a majority view, I think the majority view was that if there's a tension between originalism or the original meaning and a precedent, that the original meaning of the Constitution always trumped the contrary precedent. And that's a straightforward application of the fixation thesis and contribution principle. Today, it appears that the mainstream originalist view is that the Constitution requires some sort of federal respect for constitutional precedent by federal judges. There are different views on why that would be the case. There are different views on the extent to which that would be the case. My view, which I'm going to share and then apply in this context, is that the original meaning of judicial power requires federal judges who use that power to give precedent significant respect. My account of the original meaning in originalism has stare decisis being an important contributor to our political community's common good because it provides a nuanced way, a practical or prudent way for our legal system to address mistakes. In particular, it doesn't require dramatic overruling of all non-originalist precedent, nor does it permanently enshrine mistaken interpretations of our Constitution. And that instead, as I'm going to argue, what its move is to nudge the existing doctrine, the existing non-originalist doctrine, towards the original meaning over a period of time. I've argued in my scholarship that judges evaluating the continued viability of non-originalist precedent should take into account three factors: the extent of the precedent's deviation from the original meaning, the extent to which overruling a precedent would harm rule of law values, and the extent to which the non-originalist precedent, though mistaken, does create otherwise just relationships among citizens in the political community. Originalists using this analysis does not require preserving all non-originalist precedent, nor does it require overruling all non-originalist precedent. Instead, what it does require is that the relevant interpreter identify if there are sound reasons to follow, to limit, or to overrule the precedent. So, for example, the degree to which a precedent should be limited or overruled in part depends on whether and to what extent limiting and overruling the precedent would harm rule of law values. This legal mandate to follow stare decisis means that originalist judges will, depending on the circumstances, overrule narrow non-originalist precedent. So it's not necessarily the case, though it may be in a given case, that a judge will overrule an entire body of non-originalist precedent. For example, it may be the correct originalist view that one should not expand upon the non-originalist Commerce Clause precedents while not overruling them either. And I think this is the situation that's been occurring at least since the Lopez case and continuing through NFIB versus Sebelius. So how does what I've said relate to Dobbs? And this leads me to my second point this afternoon. My second move is to explain how Dobbs provides an example of eclecticism in American constitutional law. Dobbs was decided in an area of American constitutional law commonly known as substantive due process. Substantive due process is a purported interpretation of the 14th Amendment's Due Process Clause. Substantive due process from its inception continues to be populated by a number of non-originalist precedents, thinking of Griswold versus Connecticut and its infamous penumbras and emanations rationale for its conclusion. While substantive due process also has precedents that I think, as Professor Solum acknowledged, could be consistent with the Constitution's original meaning, even if they are not, as I'll note later, within the focal case of an originalist precedent. And I think of Washington versus Glucksberg's holding that the 14th Amendment's due process clause does not protect a right to assisted suicide as fitting the clause's original meaning, even if the precedent itself doesn't fit within the focal case of an originalist precedent. Roe and substantive due process are an example of a common phenomenon. Today, many, if not most, areas of constitutional law in the United States contain at least some non-originalist doctrine. So for those who've studied criminal procedure, you know, for example, that the Fourth Amendment, the court's interpretation of a search under the Fourth Amendment contains both originalist and non-originalist precedent. So prior to Katz versus United States in 1967, there was the Olmstead case that had a conception of search as trespass. Katz versus U.S. famously expanded or added, or I think at the time thought it was replacing search as trespass with search as privacy. And then more recently, the Supreme Court has moved back towards search as trespass. So you have a body of doctrine where there are simultaneous justifications and simultaneous precedents that are in tension with one another, some are from an originalist perspective and some are from a non-originalist perspective. Some areas of our law are deeply permeated with non-originalist doctrine. So even though the substantial effects test in the Interstate Commerce Clause context is only one test, it's the dominant test that is used to justify much federal law under the Interstate Commerce Clause today. I call these areas of law eclectic because they contain doctrine that fits more than one interpretive approach. These doctrines include, as I've argued, substantive due process, Fourth Amendment search, Interstate Commerce Clause, and there's a long list of other doctrines, which I won't belabor the point because I don't think it's contested. It's likely that there will be disagreement about which areas of constitutional law are eclectic, or at least how eclectic they are, but that the fact that there are eclectic areas of law is typically not contested. So how should an originalist judge operate in these eclectic areas? And that leads me to my third move this afternoon. My third move is to propose what I call, in a brief essay that I wrote online, a three-step program for originalism in eclecticism. Here I argue that Dobbs represents one possible and perhaps the most common originalist approach to legal eclecticism. That is, Dobbs uses the reasoning of stare decisis to prudently move a non-originalist body of law towards the Constitution's original meaning. The Constitution's original meaning in eclectic bodies of law has gravitational effect on those bodies of law, as Professor Solum had articulated. Gravitational effect in law is a common phenomenon, one that's widely accepted by scholars of many stripes, though its sources and its extent are debated. I think the most famous example is from Ronald Dworkin, who in his earlier work and then later work building on that, famously described the gravitational force of precedent as the product of the moral principles that fit and justify that body of precedent. Gravitational effect is where one aspect of the law influences other aspects. The aspect of the law that possesses this gravitational force pushes or pulls the surrounding doctrines to become more like it. Within originalism, the source of originalism's gravitational effect is the normative role that the original meaning plays within originalism. Different originalist theories differently identify normative justifications for originalism. My own normative justification for originalism is that our Constitution's original meaning secures the coordination necessary for our political community to secure the common good. On my account, therefore, non-originalist precedents do not contribute to the Constitution's coordination and instead characteristically detract from it. So judges should, absent sound reasons to the contrary, at least limit, and depending on the weight of the stare decisis reasoning, possibly overrule the non-originalist precedent and other related bodies of law. Stated more technically, originalism's normative attractiveness has the effect of modifying judges' legal reasoning by adding to their calculus reasons that move the doctrine back to the original meaning. Tying my point about originalism's gravitational power to my earlier point about stare decisis is one of originalism's tools, I think actually the most important tool, to manage originalism's pull on constitutional doctrine back to the original meaning, because it inclines judges to move the doctrine back to the original meaning by putting within their legal reasoning the additional weight and point and value of the Constitution's original meaning as the mechanism of coordination to secure the common good. And therefore in a manner, so this overruling and limiting is done so in a manner consistent with the common good. As summarized by leading originalist scholar Randy Barnett now over 10 years ago, quote, originalism has a kind of gravitational force that affects legal doctrine in significant ways, or at least that this force can affect doctrine when the original meaning of the Constitution appears not to be the basis of a judicial decision, provided that there are judges and justices who accept the relevance of originalism. So with this background in mind, I think we can see that Dobbs, even though it makes at most passing reference to the 14th Amendment's original meaning, can be fairly seen as an originalist decision. At first blush, Dobbs's opinion does not seem to be like an originalist precedent because it does not explicitly identify the Constitution's original meaning, nor does it explicitly apply the Constitution's original meaning. And had it done so, this would have been the focal case of originalist stare decisis analysis. And Professor Solum mentioned that. I'm going to come back to this point at the end of my remarks. However, if you take into account that Dobbs is in an eclectic area of substantive due process law, then you can see that Dobbs is the product of originalism's gravitational effect, and that the originalism utilized stare decisis to first move the doctrine back towards the original meaning, while second, doing so prudently, doing so consistently with what the common good requires in the context of an eclectic body of law. The Dobbs court had two related bodies of law before it. First was Roe and the constitutional right to abortion it articulated, and that was within the context of the broader substantive due process doctrine, of which Roe was an anchor point. In this context, applying the rule of stare decisis, the Supreme Court had before it four possible courses of action. It could have followed Roe, which was the dissenter's position, or it could have limited Roe, which was Chief Justice Roberts' position, or it could have overruled Roe, which was the majority's position, or it could have overruled substantive due process doctrine, which was Justice Thomas's position. The court chose to overrule Roe, modify substantive due process doctrine by both reaffirming the Glucksberg substantive due process standard, but also altering it in a way that I think actually moves that test, again, towards the original meaning of the 14th Amendment, while ultimately leaving intact the vast body of substantive due process doctrine, at least for the time being. Doing so, the moves that the Dobbs court made moved substantive due process doctrine towards the original meaning in at least three ways. First, it removed a non-originalist constitutional precedent by overruling Roe. Second, and relatedly, by redacting one of the key substantive due process cases, Dobbs eliminated that precedent's own gravitational power in that body of doctrine for future cases. And third, it modified the standard to identify fundamental rights under substantive due process doctrine towards one that is unlikely to create more non-originalist precedent because it refocused Washington versus Glucksberg's analysis to history and tradition at the time the 14th Amendment was ratified and excluded contemporary or later views on that topic. The Dobbs opinion is therefore an appropriate originalist opinion in its context. Dobbs dealt with a thick body of precedent. It first identified Roe as constitutionally incorrect, and then it employed stare decisis doctrine to limit, and in this case, overrule Roe, and whether and how to modify, which it ultimately did, substantive due process doctrine. This context also explains why the Dobbs opinion was not more explicitly originalist. Substantive due process doctrine is not an integrated originalist body of law, so a forthright originalist opinion would have been alien to that law and to many not persuasive, to many including people on the court. More fundamentally, stare decisis is a part of originalism, although as I said, there are disagreements about the extent of stare decisis analysis and how one should in particular do it. So the Dobbs court's use of stare decisis analysis is itself an aspect of originalism. What we saw in Dobbs is of a piece with other cases in similar situations. Also last year, the Kennedy versus Bremerton case, the court explicitly overruled the non-originalist Lemon and endorsement tests, expressly invoking the Establishment Clause's original meaning and left standing the history and tradition and coercion tests in that body of law, therefore moving the entire body of law closer to the Establishment Clause's original meaning, while also using stare decisis reasoning as part of its rationale for the movement of the center of gravity of that body of doctrine. The original meaning's gravitational effect is also a way to explain the Supreme Court's limiting of its otherwise non-originalist Interstate Commerce Clause doctrine. In both Lopez and NFIB versus Sebelius, the court turned to, quote, first principles and then articulated doctrinal limits on the substantial effects test. The court did not cut back on the non-originalist doctrine and instead prevented what otherwise would have been its natural extension. The Bruin case, which I've grappled with, and I know Professor Solum has written about it and I'd love to hear more of his remarks, the Bruin case might also be a product of originalism's gravitational pull. I actually think it is, but I haven't thought through it fully. So in sum, as originalism continues to have and gain support on the Supreme Court and elsewhere, it will continue to produce opinions like Dobbs that move eclectic bodies of doctrine back towards faithfulness to the Constitution's original meaning through precedential analysis. Before ending, let me close with two related points that bear emphasis. First, my analysis today was focused on bodies of eclectic law. My argument today does not apply in the same way to healthy bodies of law, that is, bodies of originalist doctrine. Second, the focal case of originalist analysis of precedent is what I call the originalism and good faith standard. Using that standard, judges should follow precedents that are the product of an objectively good faith articulation and application of the Constitution's original meaning. Eclectic bodies of law include precedent and doctrine that does not meet that standard. In other words, they don't meet the focal case of originalist decision-making and therefore are subject to pressure to move the body of doctrine towards the original meaning, as I've argued, using the stare decisis analysis as a way to do so prudently and ultimately consistently with good. So in conclusion, I made three quick moves in my initial remarks. First, I described originalism, its core commitments, and its treatment of precedent. Second, I described how Dobbs and substantive process are examples of widespread phenomenon of eclectic bodies of law. And third, I argued that Dobbs is an example of how originalism operates in these eclectic bodies of law, using stare decisis to reorient the body of law towards the original meaning in a prudent way. Thank you very much.
Thank you, Professor Strang. So I want to do a couple of things. First, if very briefly, I can kind of get a reaction from Professor Solum to Professor Strang's remarks, maybe a brief reaction from Professor Strang. And then I want to open the floor to Q&A because we already have one or two of those questions in the hopper.
Thank you. Well, I agree with almost everything that Lee Strang has said. No surprise, because his analysis is so acute and compelling. So let me just focus on two or three things where I think we have different positions. The first of those concerns the question as to whether or not originalism, qua originalism, is consistent with following non-originalist precedent that is demonstrably erroneous. That is, we know what the original meaning is. This is not a close case. This is precedent that is demonstrably erroneous from an originalist perspective. So my position is that originalism is inconsistent with following such precedents. So then I want to move to a second point. So Professor Strang says that we ought to follow that non-originalist precedent in eclectic areas where the body of law is properly characterized as eclectic, as non-originalist. And he suggests that we have reasons for doing so, that this permits the orderly progression sort of towards original meaning, and that this is justified by ideas of the common good that in Professor Strang's mind justify originalism. So I want to suggest that that's a reasonable position. And I would just tweak it a little bit. I would spend more of my time talking about the rule of law as the underlying foundational idea. But I'm really largely in agreement here as with respect to the question as to whether or not this is a reasonable or sensible thing for judges to do. But I think that it is simply a verbal trick to call that originalism. That is taking a non-originalist stance, and that non-originalist stance may be justified by the fact that we have so much non-originalist precedent that it's simply impractical to move to original meaning all at once. We need some mechanism for a gradual phase-in of original meaning. But that point is a living constitutionalist point. It's not an originalist point. Now, obviously here, I'm disagreeing then about labels, or to give it a fancy philosophical name, Professor Strang and I are engaged in metalinguistic contestation of originalism. We're disagreeing about what you should call originalist. So nothing substantive may hang on this. Okay, third point is that I think Professor Strang's reconstruction of the Dobbs opinion looks a lot different than Justice Alito's version of the Dobbs opinion. That is what was actually written. So I would agree, Dobbs would look a lot more originalist if it had been written the way that Professor Strang just reconstructed it, right? But it wasn't written that way. It wasn't written that way. And so there, of course, are lots of things that I identified in my talk that are just very, very inconsistent with what Professor Strang says the court ought to have done, right? And just to take one of those examples, if you are doing originalism, then you really, this kind of second best gravitational forced originalism, then you owe it to us to say something about the off-the-books originalism that's driving the result, right? So on the books originalism, we're upfront about it. We say why it is we're going for this second best in light of original meaning. Off the books originalism, it's happening somewhere, maybe in Justice Alito's head, but he doesn't tell us about it. And I think this is just crucially important, because if he had done on the books originalism, then he would have said something about the meaning of the due process clause, and he would have had to say something, even if it was just a bracketing maneuver, about the possible relevance of the privileges or immunities clause and how that would affect the analysis, and then why he's departing from that for whatever reasons he has for departing from that. So I agree with a lot, but there, I think, are significant points on which we might disagree, although I suspect at the end of the day, our positions are actually quite close.
Professor Strang?
Thank you so much, Philip. Thank you, Professor Solum, for your comments. One of the things that I thought was most attractive about Professor Solum's initial remarks was his point about the theory of the second best. And there's certainly a way in which stare decisis, wherever it's used in our legal system, is a theory about the second best. You have an area of law that's not coherent, it lacks integrity, and stare decisis is our legal system's way to try and identify what to do in those situations. And the standard stare decisis move is to either follow the natural import of a mistaken precedent, limit it, or overrule it. And all of those are second best, because all of those involve costs to the approach that they take. And there's different costs for different parts. So I appreciate his comments about the second best. So Professor, I'll just respond to a couple of comments, Professor Solum's three areas of potential disagreement. And I appreciate his point about whether even if there is a theory of precedent within originalism, whether it applies to demonstrably erroneous precedents. And I don't have a firm view on that yet. It's something that I'm still thinking through, and I appreciate him raising it. But I think that even if one has the view that Professor Solum has, it doesn't follow that the conclusion that judges should take in a case dealing with a demonstrably erroneous precedent would be that that precedent should be overruled. Instead, what I've argued, and I think Dobbs is doing this, is that a reasonable approach, maybe a necessary approach, so I think that's an area where he and I just haven't thought through, and maybe we disagree on that. A reasonable approach would be to limit that precedent, and then over time, the center of gravity for that body of law would move back towards the original meaning, and then over time, the precedent's power itself, that body of law that has been reoriented towards the original meaning, would itself, in coupling with the power of the original meaning itself, push any later cases towards a coherent body of originalism. So I think that even if one took his position that demonstrably erroneous precedents should be overruled, that one could still characterize Dobbs as an originalist case, because it's limiting and setting the stage for further limiting of substantive due process doctrine. Professor Solum had talked about maybe there's a linguistic disagreement. One way that I think, and actually Dobbs has helped me think through this, and I'm still thinking through it. One way that I think about stare decisis and originalism is that there are better and worse ways of doing it, and so I'm sympathetic to Professor Solum's characterization of the Dobbs majority that it could have been done better. I actually think the Kennedy case, Kennedy versus Bremerton, did a better job of it. I'd appreciate his comments as well, where the court there articulated the original meaning of the Establishment Clause, how the Eversonian project, including Lemon and including the endorsement test, were inconsistent with that original meaning, and then proceeded to overrule and carve out those negative non-originalist aspects in the doctrine. So I think that's a better way to do it. But I think that when you look at the approach of the Supreme Court, in many cases in eclectic bodies of law, they don't do that. Professor Solum gave some reasons. Some are just raw judicial politics. I think there are other reasons as well. And I think actually the mine run of cases in this area is probably more like Dobbs and less like Kennedy. So the Lopez case is an example of that, where majority opinion by Chief Justice Rehnquist talked about returning to first principles and limited the doctrine's negative expansion, natural expansion, and moved the doctrine and set the stage for the doctrine to move further back towards the original meaning in the Lopez decision. So I think it's actually it's actually a benefit of my approach, because I'm able to describe originalist approaches to stare decisis, some of which are better and some of which are worse. And Dobbs is, I think Professor Solum talked about it being off the book, and I think it should be on the book, and one can criticize an originalist justice for not putting it on the book, because that would be the focal case of originalist precedential analysis. Those are my thoughts.
Well, I want to turn to our growing Q&A queue. I want to you guys put yourselves back in your advocate days. We got about 12 minutes, and I think 3 or 4 questions to work through. 2 of them we'll take together, which is what would an originalist privileges and immunities clause argument look like in Dobbs, and what role would history and tradition play in that analysis?
Yeah, so, and I just would say that if we're looking at all of this from an originalist perspective, it's not just the privileges or immunities clause. It would also be the equal protection of the laws clause, and Professor Strang has written about that. And of course, we need to deal with the original meaning of the due process clause. So privileges or immunities clause, this is the most difficult clause for originalists for a variety of reasons, right? And so it's hard to give an off-the-cuff short answer to the question as to what the privileges or immunities clause analysis would look like. So rather than take a position, let me just suggest something that I think many or most originalists would agree on. So I think most originalists would agree that the privileges or immunities clause protects a set of basic rights, including the rights identified in Senator Howard's speech introducing the 14th Amendment in the Senate. And these rights include both enumerated rights, that is, federal constitutional rights found elsewhere in the Constitution, and other basic rights, and that would include rights connected with property and contract, the right to pursue a lawful occupation, etc. So how might that implicate abortion? Well, for the very reasons identified in Justice Alito's opinion, I think that under the description of right to abortion, it would be very difficult to make a privileges or immunities clause argument. So nothing like Roe v. Wade itself would flow from the privileges or immunities clause. On the other hand, lots of things that are adjacent to the decision whether or not to have an abortion are implicated. For example, the contractual relationships between doctors and patients, and rights to control your own body in various ways. These would be within the set of basic rights that would be included in a Senator Howard type analysis of the Privileges or Immunities Clause. So that might have some limiting implications for restrictions on abortions. For example, state statutes that impose arbitrary and pretextual limits on the abortion process, such as the requirement that abortion clinics have very, very wide corridors, might be invalid. But the core restrictions that are the heart of the Roe v. Wade opinion, it seems to me it's going to be very difficult to make a similar argument because the right to life is involved. And this is really off the cuff. I am not an expert on the Privileges or Immunities Clause by any means. And so any conclusion I reached in a context like today's event is very, very tentative. And that's really all I can say about that. What role do history and tradition play? Well, it's possible that the basic rights that Senator Howard was discussing are a function of history and tradition, that the list of basic rights or the way we identify basic rights relies on history and tradition, but there are other theories out there. And I just am just going to stop, because if I start listing the theories and talking about their relationship to history and tradition, I'll take up all the rest of our time.
I'll just say one additional thing. I think I agree with everything Professor Solum said. The additional point is that given the public context in 1868 and around the time when the 14th Amendment was ratified, you'd have to have a number of moves that would be supported by evidence and reasons to think that the original meaning of the Constitution was such that it could be applied in a way that was dramatically different than, at least in some contexts, dramatically different than the way the law was applied in 1868 and thereafter. And what I mean by that is, I think that supports Professor Solom's point that it's very unlikely you'd have a Roe-like outcome from the Privileges or Immunities Clause. But as Professor Solom, I think, rightly identified, you could have other adjacent areas where the clauses could be applied in a way that maybe don't protect a direct right to abortion, but protect against some sorts of restrictions on access to abortion.
My next question is how is the good faith precedent standard consistent with the judicial duty? That is, if a judge believes that a precedent or the reasoning underlying a precedent is inconsistent with originalism, but still applies it, hasn't that judge elevated something other than law over the law?
Lee, do you want to start?
Sure, yeah, thank you. So let me just clarify one thing first. So when I talked about the good faith standard for originalist precedent, what I meant was that it's really how does our legal system identify those precedents that qualify for the label originalist, and therefore I think are fully deserving of robust stare decisis protection from those precedents that we rightly would label non-originalist and therefore are deserving of less stare decisis protection. And the good faith originalist standard is a way to identify that. So we don't look inside the justices' heads. We don't look at their papers or their notes, the conference notes. What we look at is, in the opinion, did the majority, the author of the majority opinion, take pains to in good faith, articulate the original meaning. And so Professor Solum had identified footnote 22 in Dobbs, and that was, I don't want to call somebody bad faith, but that was not a robust piece of evidence for that proposition. And then also a good faith application. And there's going to be reasonable disagreement about whether somebody has met the level of good faith. There'll be reasonable disagreement about whether somebody has done a good faith application. And so it's a note to decide how a precedent is originalist, and then for later interpreters to be able to follow it or not. When it comes to, I think, what the question is really asking, which is how could an originalist judge or justice follow a non-originalist precedent? The argument that's out there that I know the scholars have put forward is that the power that they wield requires them to give, and then I break it down into whether it's an originalist precedent or non-originalist precedent. But for all precedent, my view is that, in putting aside the demonstrably erroneous point, for all precedent, they are required to give respect to those precedents. And so it's the Constitution's own original meaning that's requiring originalist judges to, in some instances, at least not immediately overrule a non-originalist precedent. Professor Solum?
Before you answer, Professor Solum, there's another question that may inform the way you answer this one, which is, what originalist justifications are there for requiring that the reasoning be specifically stated in the opinion? Is there anything about original understanding of judicial power that would require the reasoning to detail the sort of off-the-books originalism that you talked about, and that Professor Strang sort of said is maybe not a part of our analysis of good faith, sort of good faith look at precedent?
Yeah. So my view is that for an originalist, the constraint principle, the view that the original public meaning of the constitutional text is binding, right? Combined with a situation in which it is clear, that is, the demonstrably erroneous standard has been met with respect to a particular precedent. That if we put those two things together, then it's not originalist to say, yeah, but there's this other stuff. There's rule of law concerns or common good concerns, and there could be many other concerns that justify us from doing something other than that which is required by the law. Then that is that we have prudential reasons to depart from our duty to follow the original public meaning of the constitutional text. So we might have such prudential reasons, but they're not originalist reasons. They come from outside of originalism. Okay, and then this relates to anonymous attendees' question, right? Is the idea of on-the-books originalism baked into the constitutional text? And I've never thought of, great question, right? I've never thought about this question before, but I have a first take on it, sort of a quick reaction, and that would be to say, no, it's not. The idea that you ought to state the reasons for your judgment, right? That's part of our legal tradition. There are very good reasons for the idea that your reasoning ought to be on the books. But I don't think that the phrase judicial power has baked into it the requirement that all those reasons be presented in the text of opinions you write. It's a very tentative thought. Maybe it is. Maybe the idea of judicial power was very thick, and it included an obligation to write sort of disclosive or transparent opinions. But I haven't seen any evidence for that idea, and I would want evidence as an originalist before I got to the conclusion that that is part of the meaning of judicial power.
If it's all right, Mr. Williams, I'll just say, I know we only have 1 minute. So I think I agree with everything Professor Solum said. The one thing I would say is that, at least from my perspective, it's actually not the author of the opinion. So I actually don't think judicial power is thick enough to have as one of its elements the requirement to have a disclosive opinion. I think it's actually the later officers, so judicial officers, who are trying to, in good faith, implement their powers. And if it's the case that one aspect of judicial power is to give respect to precedents, especially originalist precedents, then one has to be able to identify them. So I think it's a good faith implementation. I don't know if it's necessarily a part of the original meaning, but it's how one, as a later judicial officer, would identify how one should approach his or her role.
With that, we come to 1:15 on the dot. Thank you, Professor Strang and Professor Solum, for Wonderful presentation, very engaging back and forth with Q&A. Thank you to our participants for your great questions. And with that, I will turn this back over to Jake.